Hello and welcome back to another episode of Courts This Week presented by LiveLaw. I am your host Syed Amir Hussain and I'll take you through the most significant courtroom developments from across the nation. From Supreme Court to local courts, I've got you covered with crisp and clear summaries. But for a deeper understanding, I will always encourage you to check out the news articles available on our website www.livelaw.in. In this episode, we are going to talk about the Supreme Court's verdict in the batch of pleas seeking a court-monitored probe related to the Adani-Hindenburg row, public interest litigations challenging the Criminal Law Reform Acts and the Election Commissioners Act that were passed in the winter session of the Parliament, UP halal ban and much more. So let's dive into the headlines. The most important development from this week came on January 3rd, when the Supreme Court declined to order an SIT or CBI probe into allegations made in the Hindenburg research report regarding stock price manipulation by the Adani Group. In response to the PILs seeking a court-monitored probe into the allegations, the three-judge bench, led by Chief Justice D.Y. Chandrachud, stated there was no basis to doubt SEBI's investigation and upheld the amendments to FPI and LODR regulations. SEBI's amendments to the listing obligations and disclosure requirements regulations expanded the definition of related party. Initially amended in 2019, the definition included those holding 20% or more of a listed entity's shareholding. Subsequent amendments on November 21, 2021 extended the definition to persons holding 20% directly or indirectly effective April 1, 2022 and those holding 10% or more effective April 1, 2023. The petitioners had alleged that these changes facilitated misconduct in the related party transactions by the Adani Group. Additionally, amendments to foreign portfolio investors regulations in 2018 and 2019, removing the requirement to disclose natural persons' ownerships, were contested. The petitions had called for SEBI to revoke or modify these regulatory changes, citing regulatory failure. The bench, however, disagreed. The court noted SEBI completed investigations in 22 out of 24 cases and directed the remaining 2 to be conducted within 3 months. It dismissed reliance on news reports and third-party organizations, emphasizing the credibility of a statutory regulator. Such reports by independent groups or investigative people, by newspapers, may act as inputs before the SEBI or the expert committee. However, they cannot be relied upon as conclusive proof of the inadequacy of the investigation by SEBI, the court noted in its judgment. Not only this, but the bench also rejected conflict of interest claims regarding the expert committee by the government and SEBI to consider the committee's recommendation for regulatory enhancement. It instructed SEBI and investigative agencies to probe whether Indian investors suffer losses due to Hindenburg's conduct, taking legal action if necessary. In parting, the court also cautioned against filing PILs without proper research and by placing reliance on unverified reports. A public interest litigation, that is PIL, has been filed in the Supreme Court challenging 3 new criminal laws, namely the Bharatiya Nyaya Sanhita, Bharatiya Nagrik Suraksha Sanhita and Bharatiya Saksh Bill, which received President Draupadi Murmu's assent on 25th December 2023. These laws are slated to replace the Indian Penal Code, the Code of Criminal Procedure and the Indian Evidence Act. These bills received clearance from the Lok Sabha on 20th December 2023 and the Rajya Sabha on the 21st December 2023. Amid the suspension of 141 opposition Member of Parliament from both houses. The petitioner, Advocate Vishal Tiwari, seeks a stay on the implementation of these laws and urges the immediate formation of an expert committee chaired by a former Supreme Court judge to assess their viability. The PIL argues that the enactment process displayed irregularities and discrepancies, lacking proper parliamentary debate, particularly when numerous MPs were suspended during the passage of these bills. The plea not only underscores the importance of parliamentary debate in democratic lawmaking, but also highlights potential challenges for lawyers in interpreting the complex laws, emphasizing their draconian nature and the risk of establishing a police state. Another public interest litigation, PIL, has been filed in the Supreme Court challenging a Gazette notification dated December 28, 2023, which pertains to the appointment of Chief Election Commissioner and other election commissioners under the Chief Election Commissioner and other election commissioners appointment, Conditions of Service and Term of Office Act 2023. The petition submitted by practicing advocates calls for the annulment of the notification and advocates for the establishment of an independent and transparent selection process. The PIL asserts the need for a neutral committee for appointing election commissioners and suggests the inclusion of the Chief Justice of India in the selection panel. For more context, the Election Commissioners Act, which recently got presidential assent after being passed by the Parliament during the winter session, aims to streamline the appointment process for top election officials in India, replacing the Election Commission, Conditions of Service of Election Commissioners and Transaction of Business Act 1991. Notably, the new act excludes the Chief Justice of India from the selection committee for the appointment of election commissioners, making a departure from the verdict of a constitution bench of the Supreme Court that had in March last year ruled that election commissioners shall be selected by a committee comprising the Prime Minister, the Leader of Opposition and the Chief Justice, till the Parliament frames a law prescribing the selection process. The bench, led by Justice K.M. Joseph, passed the direction to ensure the independence of election commissioners. The PIL filed by the group of lawyers questions the constitutional authority of the Parliament to nullify or amend a previous Supreme Court judgment, stressing the importance of an unbiased selection committee. In related news, Congress leader Jaya Thakur has lodged a constitutional challenge in the Supreme Court against Section 7 and 8 of the Election Commissioners Act. Thakur contends that the removal of the Chief Justice from the committee violates constitutional principles, asserting that it is against Articles 14, 21, 50 and 324 and compromises free and fair elections. The petition draws on the Supreme Court ruling from March, emphasizing the need for an unbiased selection panel and the inclusion of the Chief Justice in the appointment process. The selection committee outlined in Section 7 consists of the Prime Minister, a Union Cabinet Minister and the Leader of Opposition, or the leader of the largest opposition party in Lok Sabha. Section 8 empowers the panel to regulate its own procedure in a transparent manner and even consider persons other than those suggested by the search committee. The Congress leader in her petition has raised apprehensions that the impunged sections would destroy the democracy in our country and nullify the Supreme Court's judgment on institutional independence, fairness and transparency in appointment processes, free and fair elections and the rule of law. The Supreme Court, while hearing PILs challenging Bihar's caste-based survey, has questioned the government's authority to withhold detailed data. NGOs, Youth for Equality and Ek Soch, Ek Prayas and other petitioners have challenged the Patna High Court's decision upholding Bihar's caste survey. During the hearing this week, senior advocate Raju Ramachandran, appearing for one of the petitioners, urged an urgent hearing for interim relief, expressing concerns over increased reservations based on the survey. Pointing to the limitations of the bench, Justice Khanna declined this request but assured the senior counsel that the prayer for interim relief will be considered when the matter is taken up next. In the week commencing from January 29th, Notably, the judge also revealed that he was apprehensive about the public accessibility of the breakup of the survey findings. If it is available fully, then that's a different matter. The breakup of the data should normally be made available to allow people to challenge a particular inference, Justice Khanna said before adjourning the hearing. In this case, the top court has consistently refused to issue a stay, stressing the need to hear all parties at length before interfering with the government's move, especially since it enjoyed the High Court's approval. The petitioners, however, have expressed deep concerns over the potential violations of privacy rights and alleged that the caste-based survey, inasmuch as it amounts to a census which only the central government is empowered to conduct, is illegal. The Supreme Court has requested responses from investigative agencies including the Delhi Police, CBI and ED on a plea by digital media platform NewsClick and its founder Prabir Purkastia. The petition, which seeks guidelines for the search and seizure of digital devices, has been filed following recent raids under the UAPA, resulting in arrests of Purkastia and Amit Chakrabarti, the organization's head of human resources, and the seizure of devices belonging to NewsClick and its journalists. The petition argues these actions violate constitutional rights and legal safeguards. Concerns over press freedom and the government's handling of dissent have been raised. Senior advocate Kapil Sibal, representing the petitioners, in particular stressed the lack of due process during the raids. Despite its initial reluctance over entertaining an Article 32 petition, the court agreed to hear the plea after Sibal pointed to two other PILs currently being heard by the top court, which have also sought search and seizure guidelines. One is by the Foundation for Media Professionals and the other one is by a group of 5 academicians. The NewsClick writ petition has been tagged with these by the court's direction and all 3 will now be heard together. In their petition, NewsClick and Prabir Purkastia have stressed the need for procedural safeguards in the evolving technological landscape and sought writ of mandamus, directing various authorities to issue guidelines for search, seizure, examination and preservation of digital devices and data. The Supreme Court this week issued guidelines to address the arbitrary and frequent summoning of government officials by courts, presenting a standard operating procedure for high courts to follow. The SOP stipulates that personal presence should be required only in specific situations such as evidence-based adjudication, summary proceedings, or non-adversarial proceedings. It stresses that personal appearance should not be directed routinely if the issues can be resolved through affidavits and documents. The court should only direct the presence of an official when information is intentionally withheld or misrepresented. The SOP suggests allowing officials to appear through video conferencing as a first option in exceptional cases, and when in-person appearances are required, due notice should be served in advance. The guidelines aim to promote a respectful environment in courts, discouraging comments on officials' physical appearance or background. Additionally, the SOP advises courts to refrain from initiating contempt proceedings immediately and consider government pleas for review before contempt proceedings. The issuance of this SOP follows the Supreme Court setting aside an Allahabad High Court direction to take 2 secretaries of the Uttar Pradesh government into custody for alleged non-compliance of directions related to facilities for retired judges. In another significant development, the Supreme Court dismissed Congress spokesperson Pawan Khera's plea seeking to quash criminal proceedings against him over an alleged remark about Prime Minister Narendra Modi. Khera faced charges including defamation and promoting communal enmity for his Narendra Gautam Das Modi comment at a Mumbai press conference. For more context, The senior politician had triggered outrage in February 2023 after referring to the Prime Minister as Narendra Gautam Das Modi during a press conference on the Adani-Hindenburg row. The remark, seen as a reference to industrialist Gautam Adani, led to multiple first information reports and his subsequent arrest by Assam police in the same month. Khera, however, has maintained that it was a slip of the tongue and completely unintentional. Senior advocate Abhishek Manu Singhvi, during one of the hearings of the quashing plea before the Supreme Court, also pointed out that the Congress leader had issued a prompt apology on X, formerly known as Twitter. However, the top court refused Khera's plea to quash the criminal proceedings against him. They have only relied on the charge sheet, but now you go on seeking apologies and apologies. Justice P.R. Gavai told senior advocate Salman Khurshid, who was appearing for Khera. "Sorry, we are not inclined," the judge added. Justice Sandeep Mehta, also a part of the division bench, asked the senior counsel, wishing away an offence, "Is that possible?" Khera is facing charges under sections 153A for allegedly promoting communal enmity, 153B for imputations prejudicial to national integration, 500 for defamation, 504 for insult with intent to provoke breach of peace and other provisions of the Indian Penal Code. He had assailed these charges before the Supreme Court, calling them a complete stretch. In the latest development in the Krishna Janmabhoomi Shahi Eidgah Mosque case, the Supreme Court has declined to entertain a plea challenging an Allahabad High Court order dismissing a PIL seeking recognition of the disputed site in Mathura as the birthplace of Hindu god Krishna and the removal of the mosque. The petition also questioned the constitutionality of the Places of Worship Act 1991 and requested court-monitored excavation and an interim measure, asked for directions to allow Hindus to conduct prayers at Shahi Eidgah Mosque on a specific day of the week, preferably Thursday, and on the festive occasion of Krishna Janmashtami. The High Court had rejected Maheshwari's PIL, citing pending suits on the subject matter. The Supreme Court, while dismissing the special leave petition, spoke about avoiding multiplicity of litigation, but at the petitioner's request, clarified that it was refraining from commenting on this right to challenge the constitutionality of any legislation in a separate petition. Justice Khanna said, "You filed it as a PIL, which is why it was rejected. File it as otherwise, we will see." This week, the Supreme Court issued notices in 2 writ petitions challenging the Uttar Pradesh government's ban on the manufacture, sale, storage and distribution of halal certified products. The petitions were filed by Halal India Pvt Ltd and Jamiyat Ulema-e Maharashtra under the Article 32 of the Constitution. The ban, implemented on November 18, 2023, led to police raids seizing halal products in the state. The petitioners argue that the ban violates citizens' fundamental rights and disrupts established certification processes, causing chaos for retailers. The bench of Justices B.R. Gavai and Sandeep Mehta initially questioned the need for an Article 32 petition when high courts could address the matter. However, the petitioners cited the pan-India impact of the halal ban on interstate trade. While the bench issued notices, it refused an immediate stay on coercive steps under the government's notification. The ban, promoted by a BJP youth wing representative's complaint in Lucknow, applies only within Uttar Pradesh and doesn't extend to export products. The state government later granted a 15-day grace period for retailers to withdraw halal certified products. Halal certifying bodies accredited by National Accreditation Board for certification bodies have strongly criticized the government's decision. The controversial move has now also led to a constitutional challenge before the Supreme Court. The Supreme Court has upheld a judgment by the Madras High Court declining to order the removal of Senthil Balaji as a minister in the Tamil Nadu government amid his involvement in a money laundering case. The Supreme Court bench, comprising Justices Abhay S. Oak and Justice Ujjwal Bhuyan, concurred with the High Court's decision, stating that no interference was warranted under Article 136. The High Court, in a plea challenging Balaji's continuation as a minister without a portfolio following his arrest by the Enforcement Directorate, had emphasized that the governor cannot dismiss a minister without the chief minister's recommendation. The Madras High Court, while leaving the decision to the chief minister, suggested that Balaji's position as a minister without a portfolio serves no purpose and goes against constitutional principles of goodness, good governance, and purity in administration. The Supreme Court declined to entertain a habeas corpus petition filed on behalf of Indian citizen Nikhil Gupta, currently detained in the Czech Republic in connection with an alleged plot to assassinate Khalistani separatist Gurpatwant Singh Pannu in the United States. The bench, comprising Justices Sanjeev Khanna and Dipankar Datta, deemed the matter sensitive and refused to intervene. However, the court agreed to treat the petition as a representation to the Government of India, leaving it to the government to decide whether to be involved in this. Gupta's family member had filed the petition under Article 32 of the Constitution as the next friend of the detainee, claiming irregularities in his arrest, including the absence of a formal warrant and violations of his fundamental rights during over 100 days of solitary confinement. It has also been alleged that Gupta was declined consular access, contact with his family, and the freedom to seek legal representation. Now, moving to some news from other courts. The Madras High Court this week raised an intriguing question about whether a chief minister can pursue a case against the state itself. This query emerged during a hearing of a petition filed by the current Chief Minister of Tamil Nadu, M.K. Stalin, in 2014, when he was the treasurer of the DMK party. The petition pertains to the collapse of an 11-story building under construction in Maulivikam in Chennai in June 2014, resulting in 61 fatalities and 27 injuries. Then, Chief Minister J. Jayalalitha had formed a special investigation team to probe the incident. Stalin, expressing dissatisfaction with the SIT's inquiry, sought a transfer of the investigation to the CBI. The case, inactive since March 2017, came up again recently. The court questioned how the Chief Minister could pursue a plea against the state. The counsel explained that the case was filed in 2014 but taken up only now. He indicated the need to withdraw the matter as the current prayer was no longer applicable. While requesting time to formally submit these charges, the court granted the request, adjourning the matter for a week. In a recent ruling, a Lucknow court has sided with former Uttar Pradesh minister and current BJP leader, Dr. Mahendra Singh, in a defamation suit against Aam Aadmi Party Rajya Sabha MP Sanjay Singh. The court ordered Sanjay Singh to pay 1 lakh in compensation to Mahendra Singh, who had filed the suit in response to derogatory remarks made by Sanjay Singh during a press conference in August 2021. The Aam Aadmi Party leader had accused Mahendra Singh, the then State Jal Shakti Minister, of corruption within the Jal Jeevan Mission scheme. The court directed Sanjay Singh to delete related video footage and social media posts. As Sanjay Singh failed to appear in court despite summons, the case proceeded ex parte. The court observed that the defendant's defamatory statements lacked a rational basis and were found to be false in a police investigation. Emphasizing the constitutional right to freedom of speech with the reasonable restrictions, the court noted that Sanjay Singh should have exercised due diligence, verified the truth, and refrained from using unparliamentary language. That wraps up this week's legal news roundup. But before I go, I have a little request from the entire LiveLaw team. We are an independent, fact-driven media organization that is committed to fearless and ethical journalism to keep delivering your daily and weekly legal updates. Especially in this dynamic audiovisual format, we need your support. So don't forget to do the fantastic 6. Give our video a thumbs up, share it with your family, friends, classmates and colleagues. Make sure you're subscribed to our YouTube channel. Drop your thoughts and feedback in the comments below. Tap that bell icon to get your notifications. And lastly, swing by our website at www.livelaw.in for our in-depth reports. I am your host, Syed Amir Hussain, and I will see you again next time. Thank you for watching.